welcome to the WorkComp News and Views podcast sponsored by Schlossberg and Umholtz, your go-to source for insights, strategies, and the latest updates in workers' compensation. Whether you're new to the field or a seasoned professional, we've got something for you. Don't forget to like, share, and subscribe, and or leave a comment. And now it's time to sit back, relax, and enjoy the WorkComp News and Views podcast sponsored by Schlossberg and Umholtz. And good morning, good afternoon, or good evening, whenever you are listening to us, and welcome to another edition of WorkComp News and Views, sponsored by Schlossberg and Umholtz. My name is Steve Appell. I am a hearing representative with the firm, and I very much appreciate you guys listening. Please don't forget to like, share, and subscribe. That being said, this is part one of my two-part interview dealing with applicant attorneys. Of course, I've known my brother all my life, attorney Marc Appell. He's been an applicant attorney, sole practitioner for about 30 years. On the other hand, there's attorney Robert Ozeran, arguably my protege. Been doing his own shop in workers' compensation for 10 years, and boy, has he got a practice. I'll let both attorney Ozeran and attorney Appell explain it all to you in part one of my two-part episode dealing with applicant attorneys. And I'm on the phone with applicant attorney Robert Ozeran and applicant attorney Marc Appell. Hello, gentlemen. Thank you for joining me, and how are you?
Hi, good to be here, Steve. This is Robert, and I know Mark is there too, but I don't want to talk over everybody. Sorry about that.
Well, Robert, I think people in Southern California are starting to recognize your voice with all the advertising you're doing lately.
Some of the judges definitely do, that's for sure.
You know, and that's interesting. We'll get to the history in a moment, but one of the reasons why I thought this interview would be fascinating is because, of course, Marc Appell is my brother. Mark has been a sole proprietor forever, since he started about 25, 30 years ago. But Robert, you started your practice about 12, 13 years ago, and you've just taken off with the advertising and the amount of employees. I mean, you've got a staff of 10. What's it like running a big an applicant practice like you do?
All right. Well, I have a little bit more than 10.
Oh, okay.
I don't
Sorry.
want to give away my size too much, but it's greater than 10. And yeah, it took a decade to be an overnight success. So I appreciate that. And
well, you've got someone on your radio show helping you. Yeah.
Yes. My radio partner's been indispensable in that. Also, it's just it's one of those old adages that a little by a little becomes a lot, right? And so every day I just did one extra thing to move my business forward. As I used to say, turn the wheel, right? Whether it's a sign up, whether it's a settlement, right? Whether it's sending out a deposition invoice. Those types of things, those income generating activities, you move the business forward one step at a time every day. And then all of a sudden you're doing multiple things per day. You're doing multiple signups per day, multiple settlements per day, multiple depositions per day. And before you know it, the wheel is spinning really fast. And you just have to try to keep up. You have to hire people to manage the caseloads and reception, and then with that, you need to get more clients, so you try to get into advertising a little bit more. It's the American dream, honestly, of building a business. Just over a period of time, a little bit adds up.
Mark, you've been a sole practitioner with one secretary, the same secretary, for 20 some odd years. Would you want to well, Robert didn't say it was crazy, but would you like to have all that responsibility, or do you purposely keep yourself a one-man show?
It's probably a little of both. I've been doing this 33 years, and I've been on my own in one form of another this is actually my 30th year in solo practice. and I've had the secretary for several decades now. Part of it is I like to keep things small because I like to be able to give a little more personal detail to each case. I mean, and I've never wanted to put out that financing for advertisement, and not that I would ever ask Robert, and I'm not that he should ever have discussed with anybody, but I'm sure he's got a nice advertising budget which probably pays for itself. And the idea of that many clients is a bit daunting, and maybe that's just never been in the cards for me. But as we know, this is a high volume business to be an applicant's counsel. So for me, a lot of it's been about keeping overhead small, but also because half of my practice is civil litigation, which I do all myself. I probably type faster than any secretary. Would I want to do it in the end? I don't know. At this point, it just is what it is. So if it starts to become something like that still, while I'm still alive and still kicking, I'll probably take it. But for now, it is what it is.
Robert, with the size of your practice, I can't imagine that you have hands on with all of the files at all of the time. I mean, clearly at a deposition or trial, it's you. But when it comes to the day-to-day operations of communicating with everybody, you need that help. How do you maintain the professional conduct and communication that you want your office to continue to aspire to?
Wow, Steve, these are some excellent questions. You really prepared. And I agree with you that it becomes more difficult to keep the feeling that I individually care about this client's case, while also maintaining an advertising stream to always be bringing in new cases. And that was my goal from the beginning, actually, which is to give people the feeling of a mom and pop business, of that, comfy feeling that you know who your lawyer is, you know who your paralegal for the day-to-day, medical appointments are. But also on the backside of that is it's actually a large business. So that combination feeling where the clients feel that they're taken care of by a smaller mom and pop style business or a sole practitioner business, while actually having the security of knowing that this is actually a big and reputable firm. They want both. It's right. People want things that taste good and are also low calorie. It's that type of situation, and I try to give that to people as best as I can. I know what people want. I want the same thing when I had my own, legal questions when I was younger. So maintaining that is a day-to-day challenge. I think it's the number one complaint that I get from customers, from clients, is that there's not enough communication. Even if we communicate with them on a regular basis, there will never be enough communication. The clients will never be satisfied. So you have to kind of pick a standard as an attorney where you keep notes, where you keep a record saying, actually, we spoke with you 3 days ago and we informed you about this. Here are the notes. Paralegal A, B, or C spoke with you. And then I always make myself available for every single client. Will I be able to do that moving forward indefinitely? Maybe, maybe not. I mean, I'm a human. I get burned out. I want to take time off. I want to go on vacation. I want to get a dinner, right? But yes, right now I'm always available, especially for people who are seriously injured. I will always make myself available for those serious injury cases. Now, I've found that often the more serious injury cases, actually, they are not as demanding as the people who worked for 6 months and filed a psych claim post-termination 3 years ago. For some reason, it seems to be uneven. And so part of my intake process, and by the way, I look at every case, every single case that comes in goes through me, and every single settlement goes through me personally. So,
And everybody in your office is supervised by you, right?
Correct. But I mean,
Yeah,
what do
yeah.
we mean by supervised? If you're going to get a QME panel, I don't sit there over your shoulder and make sure that your specialty is correct. I'll assume that you know what you're doing.
But I'm assuming
And
you're
there's a
involved
problem.
with the striking of the panel, right? Maybe not.
No, usually no. We have a
Oh,
list.
Oh,
and
gotcha,
we know which
gotcha.
doctors we have. We have like so yes, I have been previously involved to the point where people know who I want and who I don't want,
Yeah,
like a grading system.
you've got like a list. Mark, any problems with communicating with clients these days?
Um, no, but remember again, we're smaller base. Most calls go to my secretary first, and she can handle 9 out of 10, 95 out of 100 because she's been doing it forever. And if they need to talk to me, then they get to me, and we try and return all calls or emails within 24 or 48 hours. But I agree with Robert 100%. I think the single biggest complaint in this type of business on an applicant or a plaintiff side, and in is that, and the single biggest reason that clients switch attorneys is lack of communication and or a failure to communicate. And I also agree with Robert that the bigger cases are not as difficult. The smaller cases is where they need more handholding, and it's frustrating, and it's a self-fulfilling devastating prophecy that it's just never enough. You do whatever you can, and the next thing you know, you don't hear from them for a week, and you get a sub out. So
Um,
we
here's
just do our best. We do our best to respond timely and fully.
speaking of
Yeah.
communication. I think this is the question that all of our listeners are really going to want the answer to. Robert, communicating with defense attorneys, good points, bad points, problems. What do you think?
All about relationships. All about relationships. I have cases where I will file the application, and within 30 days, I'll have a defense attorney calling my cell phone offering me money, and a fair amount often. And I have more than one defense attorney who does this. It's because we work together so many times, and we've worked well together. It's almost like we're friends, but we are not friends because I don't know where they live. I don't really know anything about them personally, right? But it's a relationship. And then there's the defense attorneys that I don't really get along with, that for some reason the files, when they get in their hands, they get a little sticky, and they don't seem to want to relinquish them. They don't want to settle it. They seem to argue over everything.
Is there, do you
Yeah,
find anything in common or similarity with those types of defense attorneys, i.e., either how old they are, who they work for, or how long they've been in this business, or just no similarities at all?
I would notice, I'll leave this next one to Mark too. The older defense attorneys
Yes.
are often the ones who, if they get a file, they're a little stickier. They don't just say, "Here's some money," and I know where this is going to
Or
go.
slower.
I know how. Yeah,
Lower.
but some young attorneys also seem to take too many things personally. All of a sudden, they get assigned a file, and it's like you personally offended them, and you're thinking, you've been in this case for 10 minutes. Uh, it really is a personality issue. I've noticed that older defense attorneys seem to have a bit of an ego more than younger attorneys, and this ego, uh, it's very difficult for me to deal with them. I'm always as polite and professional as I can be, but inside I'm thinking, I don't like talking to you, because they've done this so long that they feel that their opinion is greater than yours, and it was greater than the judges. And this is the way it's got to be. I have a picture in my head of an attorney who I'm thinking of right now
And
when I
we're
say
not
that.
going to mention his name. Robert, you've been doing this for 12 years. Mark, you've been in comp 25, 30 years. What are your thoughts on this topic? And that's a good place to take a break, because I actually reversed it. Robert's been doing this for 12 years, and my brother Mark's been doing this for 30. We're just taking a very short intermission. You're dialed in to Work Comp News and Views, sponsored by Schlossberg and Umholtz. My name is Steve Appell. I'm a hearing representative with the firm. If you like what's going on, please like, share, subscribe. This is part one of our two-part episode on dealing with applicant attorneys. We'll get back to it.
About the defense attorneys?
Yeah, dealing with defense attorneys, yes.
I agree with Robert. A lot of it is the personalities and the relationships you have. Obviously, the attorneys I get along with best, I have their cell and they have mine. and we text and call at will. I notice these defense attorneys, they have 100 cases or 150 or 200, and they're overwhelmed with that load, which is funny when you think about Robert and his load and my load, which is even, probably close to that. And these guys can't handle it. And a case ends up and it just disappears into the black hole of their endless trying to bill for a living, and you never hear from them. And the only way to get anybody's attention is to file for a hearing, a DOR. But the ones that you know and that you get along with that will talk to you, they don't take it personally. Their job, their goal is to work with you to try and get something done. I notice the younger attorneys think they have a lot more to prove, and they get easily offended. And I'll give you an example on a case I had a couple of years ago, where they were asking my client in a depot for the make and model and license plates of their car, and I instructed my client not to answer. And the guy got so upset, he said, "I'm going to end this deposition and move to compel." And I said, "Go right ahead, you're not getting it." And he actually did. Not only did they not file a motion to compel, but a week later, the partner took over and called me and said, "I'm sorry, don't worry about it." So, when the egos get involved, especially with the younger ones or the really, really older ones who just have checked out, it's a problem. But the ones in the middle, the ones that Robert and I know very well, because this is a small community that you deal with people over and over again. If you can just keep it civil and be nice, and they know you know what you're doing and you're pleasant, you do okay.
Speaking of communicating with defense attorneys, what percentage, Robert, do you communicate by telephone? What percentage by text? And what percentage by email communicating with defense attorneys?
It's an interesting question. I can just go by how things went for me today.
Yeah.
For example, today I texted with a defense attorney. I emailed with a couple of defense attorneys, and I spoke on the phone with 2 defense attorneys and an adjuster. So I would say it looked like 3, 3, and 1.
How about
emails, 3 phone calls?
How about you, Mark?
Mine is almost always starts with an email.
Mm-hmm.
And if I don't, then I follow up with a phone call. And if I don't get a response to the email the same day, I'll text the attorney that I know, and they'll usually call me. But I think the benefit of the email is it's instant communication. But obviously, I think we've lost something. We've lost personal communication. It makes it a lot easier not to talk to each other, which email is a benefit and a curse. But I'm as guilty of it as anybody else. I typically start with email because this is more my civil background. I'm always making a record of whatever's going on in a case. And you have that with an email where you don't have it in a phone call.
Robert, about 10 years ago when I was managing an applicant's practice, you opened your firm and you started signing up clients by DocuSign. And although I knew what DocuSign was, I thought that was crazy. We always had it mandatory that, with the exception occasionally of going out to a client's house and signing them up, they had to come into the office. And now all applicant attorneys are signing up their clients by DocuSign. You were like an innovator. What would you like to say about any other innovations that you're doing now? Yeah.
Well, thank you, Steve. Well, what can I say? Necessity is the mother of invention. I wasn't trying to be creative at the time. Yes, you're right. I was like 10 years ahead of the curve. Remember, I used to have a job as well. When I started my office, I didn't just open up and hang my shingle and off I go making money. I worked a 9-to-5 job for other law firms. And at night, I would work for myself, right?
And
I worked all day, every day.
refused to work for a defense firm because I introduced you to judges and defense attorneys. You were offered great salary packages, but you turned it down because you knew that you wanted to represent the injured worker.
Well, I knew I wanted freedom and to be my own boss. That was my greatest motivating factor, is to be an entrepreneur, to have a business, more than just a salary. And then I also have a passion to help people. So combined, it seemed like my path was set out for me. I never thought about it in such terms that are, now I'm retrospective. But at the time, I was just going by how I felt. and I felt I wanted freedom, and I felt I wanted to help people. But I also knew that I couldn't just hang out with a shingle there and start signing up clients and paying for advertising, because in business, you really don't know what you're doing. There are books, but there is no real instruction guide, because the questions come to you in the moment and you have to answer them. Well, I think that's what they say about life is versus school, right? In life, the test comes first and then the lesson, versus school, where you get the lesson and then the test. So in life, you get this test right away, and you have to figure out the answer on the spot. And for me, it was, well, I need a paycheck. I need to work. So I worked for a couple of applicant attorney firms during the day. And then I was working on my own cases at night. And then one day, I just simply made enough money where I didn't need to go to my day job. I had my own office now that I could work at. And there was you can call it a temporary income interruption, where there were some very trying times, some very anxious moments of whether or not I could survive. And I don't want to get too, religious here, but I do feel that God helped there, right? Laid the path out, and every time I needed a check, the check would arrive in the mail, and I was just living like that, moving forward until one day I had 2 checks in the mail, then 3, then enough that I could actually feel satisfied that, all right, I'm not feeling insecure about things right now. But nothing gets you up in the morning like hunger and necessity. I tell you what.
Mark, you've been doing this for over 30 years, but you use technology to its benefit. You want to comment?
Well, first I want to ask Robert, does God help your friends too?
Maybe.
Because occasionally, I could use that help.
Okay.
Faith is important. I operate every day with faith. That's my real partner in all of this. You can call it almost delusion, because you have to be a bit delusional to think that you can get out there without security, without a safety net, and to do something like opening a business. So you do have to have a lot of faith, and whether you want to call it God, faith in yourself, or all of the above, faith is a definite partner here.
God, I kid you guys. God is the last thing I thought we'd be talking about. Actually, I didn't think. But Mark, go ahead, please.
Well, I started going paperless over 10 years ago, and it's been an ongoing process. I unfortunately didn't jump on the DocuSign e-sign bubble until about 2 years ago. But talking about God, that's a godsend. Okay. To not have to get the wet signatures, although there are still a few judges out there who were rejecting DocuSign documents. I think as of January, Robert, maybe you know this, that it's uniform accepted now that there's no cause to reject, like a CNR, that it doesn't have a wet signature, that it's DocuSign. But the ability to be able to be paperless, first of all, in this business, to be able to be paperless, I don't understand anybody who has hard files anymore, but to be able to get those digital signatures, it saves so much time. Again, you lose a bit of the personal connection, not having the client come in to sign something, but the ability to be able to represent somebody in San Francisco when you're in LA, when all you have to do is email and DocuSign, it opens up a world of possibilities for your business, and it's been an incredible help, especially over the last year or two.
Speaking
And
of,
you know what, Steve,
go ahead.
I could actually piggyback on that to give Mark a little bit of, and for your listeners, I know exactly what you're talking about with that personal touch that's missing with an electronic sign up. So what I have done, and what I've done, this is for 10 years now, is you get some marketing materials, whether it's your business card. I have a folder with my picture on it from one of those online companies. I use Vistaprint, and I put all of my clients' opening packet documents, whether it's the application that was electronically signed, the DWC-1 claim form, all of the letters that we template out, and I send that folder to my newly signed up client. And when they receive those materials, those marketing materials with your picture on it, with a business card, right, with a hello letter, saying this is your packet. These documents were sent to everybody, and a copy is going to you here, so you know what we have used your electronic signature for, in case you forgot. Right? That right there starts to create that connection between me and my client, where even though they have not met me personally, they've spoken to me on the phone, they've heard my advertisement, they've heard my voice, and here's my picture with your signature on it, right? And that starts to create that connection.
I like that. Really good.
Speaking of going paperless, I haven't been to a trial at the WCAB in a couple of years, but I would bring, the last time I went, my hard file. I see Robert and I see other attorneys bringing their laptop, and I just don't know how it's done. I want to go to Marc first. Marc, when you go to trial, do you bring a hard file? Do you bring a laptop or a combination of both?
I have my laptop, but typically in trial, I'm only using my iPad, which is basically the laptop. But I'm completely digital when it comes to trial, except the notes that I'm taking, which I tried once on a laptop, and it just doesn't work for me. So I take notes on a regular legal pad, but all of my documents that I'm using are digital most of the time, just with my iPad.
Robert, I know you're digital. You want to talk about it going to the board for trial?
I am absolutely identical. I bring a clipboard with a legal pad. I write things down, but everything has been e-filed, and I do have my iPad or laptop. I have both. Depends which one I want to use that day. And the exhibits are all there, and they've all been previously e-filed. So I am exactly the same as Marc right there.
And with that, that ends part one of our two-part interview with attorney Robert Ozeran and attorney Marc Appell dealing with applicant attorneys. Thank you very much for listening to Work Comp News and Views, sponsored by Schlossberg and Umholtz. My name is Steve Appell. I'm a hearing representative with the firm. Please share, subscribe, like, and don't forget to check out part two. And of course, last but not least, thank you very much for listening. You've been listening to the Work Comp News and Views podcast, sponsored by Schlossberg and Umholtz. The opinions expressed on Work Comp News and Views are for entertainment purposes only and not to be considered legal advice. Don't forget to like, share, and subscribe, and or leave a comment. Also, feel free to send an email directly to sappell@schlossberglaw.com. For Work Comp News and Views and Schlossberg and Umholtz, my name is Steve Appell, and thanks for listening.